Good morning, Ms. Sullivan.
Good morning, Your Honor. May it please the Court. My name is Catherine Sullivan. I'm an Assistant Attorney General representing the Commonwealth of Massachusetts. With me is Assistant Attorney General Gwen Werner. Both this case and the following case deal with individuals convicted of crimes who were granted their liberty based on errors at their trials of constitutional dimensions. After the individuals were released from custody,
It would be very helpful to me. I know what the next case involves, but it would be extremely helpful to me if you did not try to sweep in the next case. So just talk about this defendant, not individuals, just this defendant, okay?
Absolutely, Your Honor.
Because it seems that there are some quite significant differences, so I want to make sure that I understand your argument just for this case.
I will be sure to do that, Your Honor.
Thank you.
After Mr. Drumgold, the individual in question today, was released from custody, the statute before the Court today was enacted, the Massachusetts Erroneous Convictions Law, which was enacted on the last day of 2004. In that statute, the legislature created a process whereby a narrowly defined class of erroneously convicted persons may receive compensation of up to $500,000 and in addition receive services designed to assist them in rebuilding their lives. The provision at issue here is found in the second paragraph of that law, which in the case of, which creates two parallel gatekeeper provisions. One, in the case of a pardon, where if a pardon is issued, the governor must have stated in writing his belief in the individual's innocence in order for that individual to pass through the gate and be eligible to file a claim under the statute. The parallel provision at issue here is requires the individual to show that he received judicial relief vacating or reversing his conviction on grounds tending to establish his innocence.
And in this case, you had a kind of mix of reasons that were asserted.
Correct, Your Honor.
And as I read, this is the one with Justice Rouse,
Justice
right?
Rouse, correct.
She basically said it wasn't this, it wasn't that, but all in all, justice wasn't done, and therefore, for that reason, a new trial should be granted. Is that?
She stated that that a number of constitutional rights were violated, in particular, the right to a fair trial, and that because of that, she was granting the Commonwealth's motion for a new trial. She then went out of her way to say that she was not relying on any specific ground raised by the defendant in his, or the plaintiff here, in his motion. So I think that from that, we can conclude that the grounds raised by the defendant, pardon me, it is easy to get confused, by the Commonwealth were those that she relied upon.
So the Commonwealth, at the end of the day, was, because I remember Mr. Meyer saying it wasn't this, it wasn't that. What did he finally come down and say, this is the reason?
Fair trial. He also said fair trial, didn't he?
But what about it was not fair?
He didn't say.
Well, he did. He reviewed. There was an extremely long evidentiary hearing in this case with many witnesses. And the prosecutor filed a memorandum of law, which is in the record, at which he reviews at great length both the facts and the law relating to those facts as to each claim. And he comes along to two claims which he tells the court should rely upon. The first, and he says that it's really together that those two claims warranted a new trial, not each of them individually. Okay. Both related to witnesses. The first related to a witness who, it turned out, had brain cancer. And it was pretty much agreed at the evidentiary hearing on the motion for new trial that that information was not known to anybody, not to the defense attorney and not to the prosecution.
This is one of the identification witnesses.
It was one of the identification witnesses. The other, and so it went to the potentially the testimonial capacity of that witness. There was no, the witness had died by the time of the 2003 hearing. She had been dead for about 10 years at that point, or it had been about 10 years since the trial at that point. So, so there wasn't any further development of the details relating to her case medically. The other area that the Commonwealth sought, the prosecutor sought, asked Judge Rouse to rely upon, was the failure to disclose favorable treatment to another Commonwealth witness. That Commonwealth witness had was acquainted with Mr. Drumgold, and he and his brother had been present with Mr. Drumgold when the co-defendant, Mr. Taylor, who was acquitted later, came up and said, come on, we've got to do this. And they both had guns, and off they went. And then later they came back, and this witness was also present, and he said, hey, what happened to the guns? And they said, well, they're hot. We had to stash them somewhere, and they acted nervous. So that was his inculpatory evidence that would have been affected by the fact that he was housed, fed, his warrants were cleared right before trial.
Ms. Sullivan, forgive me for interrupting you, and I certainly don't mean to fault either counsel in this case or the judge hearing. This was a motion for a new trial, which was granted, and then the assistant district attorney said that they were not going to re-indict. This, as you noted at the beginning, occurred before the erroneous convictions law was enacted.
Correct, Your Honor.
So understandably, nobody in this proceeding is trying to be very clear about what might or might not be looked at afterwards. And I'm not sure if that's good or bad for us. But as I read Mr. Meyer, he does go through various things, but what he is really saying to the court, and this is on page 7 of the transcript, when all is said and done, as the Commonwealth sets forth in greater detail in its memorandum. Is that memorandum on file with us?
It is indeed, Your
Okay,
Honor.
I just haven't read it. That's okay.
Yeah.
When the evidence adduced during the hearing is viewed in the context of this entire case and the nature and quality of the evidence at a trial which centered on 2 or 3 shooters wearing masks, dressed in non-distinctive clothing, without physical evidence. I mean, he's essentially saying we didn't have a lot to go on.
I think that's right, Your Honor.
Without forensic or scientific evidence, without any admissions or other incriminating statements, when viewed in the context of each, the Commonwealth respectively suggests that justice was not done and that, in fact, Mr. Drumgold did not receive a fair trial. I think it's very difficult for us to go back in the light of that statement and say it was this, it was this, it was this, it was this. I mean, he does highlight some of the claims, but essentially he's saying it wasn't a fair trial.
I can actually give the court just briefly a couple of pages to look at in the record. I would refer the court.
We'll look at the whole thing. It's okay.
Okay. All right, but there are several places where the prosecutor in his memorandum states specifically that certain evidence is not credible and should not be relied upon, and it's basically all the other evidence that was presented at the motion for new trial hearing. But those pages are 71, 73, 87.
You're talking about in his memo?
No, these are the record appendix that's
Okay, yeah. But that's his memo.
numbered.
That's his memo, not what he's saying.
This is his memorandum of law,
okay, yeah,
correct.
Yeah. Okay.
And then in addition, during the hearing on page 93 of the record, which is page 5 of the transcript, just a couple pages earlier from where Your Honor was looking at the transcript. So I do think that there isn't any real dispute about even though, of course, there was going to be no appeal. Both the prosecutor and the defendant.
I have a very basic question, and maybe I'm missing something, but is this case properly here? I know you cite Brum versus Dartmouth, but Brum versus Dartmouth says if an appeal from final disposition of the case would not be likely to protect the party's interests, the order is appealable. Why wouldn't you be protected after, if there's a trial and if there's a judgment against you, why wouldn't you be protected by an appeal?
Yeah, Your Honor, it's the classic immunity defense issues.
No, I understand that,
but
but so is Brum, and I'm reading from Brum, and I'm saying that you could be satisfied after. I mean, your rights could be vindicated after a trial.
But if
that
there's
could
a
be true.
sovereign immunity, they shouldn't have to go to trial at all.
Your Honor, it's the same
But
situation.
sovereign immunity has been waived by a statute here.
Right,
So it's
Your Honor.
waived, and you can still.
I totally understand what Your Honor is asking. It has to do with, of course, at the end of trial, if we have to pay money or if we have to provide services, we can appeal at the end of trial.
Right.
I understand totally the question. The same thing was true in Brum, Your Honor, and the doctrine of immunity is designed to do 2 things.
But it's
First,
waived.
to protect from.
That's Justice Cowen's question. It's waived.
It's waived by the statute.
Only in limited
And
circumstances.
it's been waived.
Right.
And
But
the
we're
government has
arguing-
decided to waive the immunity against it. So why can't you be vindicated after trial?
Right, and I would say the court to the Vining case.
The what case? Vining?
Vining, it's just a case under the Mass Tort Claims Act, but it also it states that Vining, it only arose because the motion for judgment on the pleadings in that case was filed out of time. So it was not going to be heard or proper unless it could be filed at any time, and it could only be filed at any time if it were jurisdictional, and it could only be jurisdictional if it related to sovereign immunity. So through the back door, the issue came in Vining. And the court said absolutely. These are, even though, of course, the Mass Tort Claims Act has waived immunity, when you're talking about whether a case falls within the contours of the statute that waives sovereign immunity, which is supposed to be strictly construed, and that's what we cited Vining for in our brief. But it also explains a little bit, it can be emblematic to the court of the situation where, of course, you have a waiver of sovereign immunity. No one would dispute that. Tort Claims Act, 258D, very important provisions for eligible persons to get compensation. But if the issue is that either something about the claim or something about the individual circumstance places that claim outside the contours where the legislature stated sovereign immunity is waived, then you do assert sovereign immunity, and the issue is...
I understand that.
Yeah,
I think
I'm sorry, didn't mean to belabor
the difficulty for me is on the, tending to establish, because you could have had a pardon or establishing his innocence. You could have had that. In other words, you may be able to establish your innocence and not have a pardon. There may be all kinds of reasons why the executive branch doesn't give a pardon.
Important language.
Or establishing your innocence. And I know you're framing it as a jurisdictional question, but it seems to me that it's a very fact-specific question. And as I say, I don't fault what happened here because it was before the statute, so we sort of have to push back. But it's very, very hard to say how on jurisdictional grounds you could say that this wasn't tending to establish.
Your Honor, if it can't be said here, even though I fully agree the judge's rulings and findings are quite short, then it might not ever be able to be said, and I think this is an extremely important question.
But why, as a matter of summary judgment, they fail to satisfy proof on one of the elements of the offense, or one of the elements of the claim? Why doesn't it come up? Why isn't it appealable after summary judgment is just an order is entered on summary judgment?
That's exactly what happened here, Your Honor. Exactly.
It was
On the
denied.
merits.
It was denied. The summary judgment was denied.
Right. The Commonwealth appealed after summary judgment was denied.
But that's not a jurisdictional. That's my point. It's not a jurisdictional argument. Right. It's a straight SJ or not SJ. And in the other case, I think summary judgment was granted. Correct.
Correct, Your Honor.
We flipped. That's why I wanted.
Yes, but in this case, summary judgment was denied. Just as in Vining, there was a motion for judgment on the pleadings that was denied.
But
on the ground,
wasn't it denied? Isn't the real reason it was denied was that there is a question of fact here?
it was denied on grounds that both the Commonwealth would disagree with and would request that this court speak to. But it was also denied in the face of a claim of immunity. And if the Commonwealth's right to immunity is to be protected, it must have the ability to have the immunity come into effect before a trial and before discovery. And that's what Brum versus the town of Dartmouth stands for. And that case...
No, that's correct. And I take it when we look at all the procedural history, you first had it decided on jurisdictional grounds, and then when you lost that, you had it decided on summary judgment grounds?
Your Honor, it was a motion for summary judgment.
But normally what you would do is you'd move to dismiss.
That's correct, Your Honor.
Because summary judgment assumes jurisdiction.
I will not, I'm not attempting to bring in the other case, but in the other case we did move to dismiss, and it was treated as a motion for summary judgment. This came after, and so there was some question about which is more appropriate.
But generally speaking, just to clarify what
Yes.
we should, if we're trying to figure out what to do with these cases, if the Commonwealth believes appropriately that it is beyond the jurisdiction of the waiver, it is beyond the jurisdiction because the waiver of sovereign immunity doesn't apply here, it should file a motion to dismiss. If it loses on that, it may nevertheless win on summary judgment, correct? It could.
No, Your Honor, I don't believe so.
You really think no?
I don't believe so, no, because
Tell me
really
why.
this is a pure question of law. The question here is, we have the complaint.
Mm-hmm.
The complaint states, I was an erroneously convicted person and I'm eligible.
Mm-hmm.
And impliedly includes the decision on appeal or on a motion for new trial that is recited in the complaint. So it's a pure question of law. If we do the same thing on summary judgment, it's as a matter of law, the person is entitled to judgment. And because there are no material facts in dispute as to that question of law. Are we?
I thought I was helping you, but I obviously wasn't.
Yeah.
I thought you could have I thought you could have two bites at the apple under different hats, but you're telling me that no, I can only get one bite at the apple.
I think that there may be cases in which something changes, an appellate decision might come down in the middle, but in general, no. I think it's the same issue, Your Honor, and I see no reason that it can't be either.
Mm-hmm.
Interwoven in all of this is your view that the question of whether or not this person is eligible is a question of law, and that whether the grounds tend to establish innocence is not a question of fact that should be sent to a jury. It is a question of law that needs to be addressed or should be addressed by the judge.
Correct, Your Honor, and it would be terribly unworkable if, for instance, a case went to a jury trial and the judge concerned that perhaps there would be material issues of fact that would still be extant and that the case should be really first resolved by a jury and then everything could be sorted out on a further appeal if necessary. If that occurred, you could have the illogical result of a verdict on the question of has the plaintiff shown by clear and convincing evidence that he is actually innocent? And then that could all be taken away because it was determined that he had not, the judicial relief did not make him eligible because it didn't rely on evidence that under the statutory standard tended to establish innocence. I know I'm short on time, but I want to...
Oh, you're not short.
All right.
You're over.
I want to... Oh, I'm sorry, Your Honor.
That's okay.
May I...
No, we really are. We just
Yes.
keep moving, and
We will.
believe
Thank
me,
you,
we'll
Your
read
Honor.
it.
Well, she
Thank
will
you.
get another bite at this apple, right?
I will request that the court reverse the order of the Superior Court.
Thank you, Ms. Sullivan. Mr. Riley?
One, Your Honor, may I please the court, Michael Riley for Sean Drumgold, with me as my co-counsel Rosemary Scapiccio. 258 Section 1B2 provides that to qualify for relief, a defendant needs to establish as one of several hurdles that he received judicial relief on grounds which tend to establish innocence.
And why isn't that a question of law that the court ought to be deciding?
I think it is.
Okay.
I think it is. I think that it is for the
So then are
court-
you saying that you think the Superior Court judge was wrong also? Because he said there were questions of fact.
No, because I think on the record before Judge McDonald, there were material issues of fact, because the record before Judge McDonald did not allow him to do anything other than rely on what Judge Rouse...
But then it isn't a question of law.
Well, I think the judge needs to make factual findings. You're correct. What I meant to say is it's a question for the court. I think it's a question for the court to make after making factual findings, looking at the circumstances of the case.
But doesn't this question really pose the issue, what did the judge below do? What were the reasons for the judge having allowed, in this case, the motion for new trial? And as a matter of law, do those tend to establish innocence, or do they not?
Yes, and I think that the Commonwealth, by motion for summary judgment, needs to put a record before the Superior Court judge to allow that judge to determine what was the basis for allowing judicial relief.
Do you agree that you can't figure out, based on Judge Rouse's statements, whether or not there were grounds which tended to establish the innocence of the individual?
No, Your Honor, I don't agree to that.
Because she goes out of her way to say, I want to emphasize that nothing in this ruling in any way should be construed as a specific finding or determination by this court as to any grounds advanced by the defendant in his motion for a new trial that includes his allegations of police and prosecutorial misconduct, nor should this ruling in allowing this motion in any way be taken as any finding or determination about this defendant's guilt or innocence in connection with the murder of Tiffany Moore.
And I think the distinction that the statute makes is, as a first level, you ask, do the grounds tend to establish innocence? Not do they, Judge Rouse correctly says, she's not finding there was innocence. Do they tend to establish innocence? If there's been exculpatory evidence withheld, you can't get a new trial unless that was a substantial effect on the trial. If there's been newly discovered evidence, you don't get a new trial unless it substantially affects the outcome.
But what happens under Chapter 258D? If it gets to trial, does the plaintiff have to prove actual innocence?
Yes, Your Honor.
Okay, so the question of actual innocence comes up on two separate occasions. There judicial relief, using this prong of the statute, must have been granted on grounds that it tended to establish his actual innocence, and that's a question of law for a judge to decide. If the answer to that question is yes, then he gets a jury trial on the question of his actual innocence.
That's exactly correct, Your Honor. And I'll just add, there's a second step. First, you need to show you were given relief on grounds which tend to establish innocence. You then need to show that, in fact, the charges against you were either dismissed, null pros, or you were found not guilty.
So Attorney Sullivan is right, though. This is the first inquiry into into innocence, whether a judicial relief was granted, is a question of sovereign immunity.
I don't know that I agree it's a matter of sovereign immunity. I think it's a matter of whether you fall into the category under this particular statute.
So if you don't fall into that category, sovereign immunity applies.
Well, you're simply not entitled to relief under the statute.
Well,
I suppose
you have no other way to get money from the Commonwealth.
That's correct, Your Honor. I mean, in the sense that this is a waiver, the statute itself is a waiver of sovereign immunity. You're correct. It seems to me, though, that the question for this Court is one of statutory interpretation.
Yes.
Now, should we not recognize that there are at least two categories of newly discovered evidence and exculpatory evidence? One, that there was evidence that goes to impeach the evidence offered by the Commonwealth, which either is newly discovered or was not revealed to the defendant and therefore could not be used at trial. And there's another category which indicates that the defendant is actually innocent. That is, DNA evidence to suggest that he's not, or to make clear that he wasn't the person, or an eyewitness who says he was with me at the time. Why should we not interpret this statute to say that the grounds for the dismissal have to be based on that second category of exculpatory or newly discovered evidence and not the first category?
I think for two reasons. First, that's not what the statute says. The statute says grounds which tend to establish innocence. And secondly, as a practical matter...
Actual innocence, not grounds that would undercut guilty beyond a reasonable doubt.
The statute says tend to establish innocence, but it means actual innocence in that context. The second problem, though, is in a case, for example, where the Commonwealth has one witness against a defendant, and there's a motion for new trial that completely undermines the credibility of that one witness, it seems to me in any reasonable reading, that's grounds which tend to establish innocence. The only witness committed perjury. It wouldn't meet that second category. It's not evidence that someone else did.
But basically you're saying that grounds tending to establish innocence is exactly the same as how we define exculpatory evidence, which is that right?
I think the distinction that the legislature was making was the distinction between exoneration for a new trial for newly discovered evidence or exculpatory evidence versus
his motion to suppress should have been allowed.
Yeah, a motion to suppress not allowed. A voir dire was done improperly. A speedy trial were denied. There are all kinds of grounds on which a defendant gets a new trial that does not tend to establish innocence.
No, but the defendant thereafter has to get the charge dismissed. So.
But if a defendant gets a new trial allowed or a conviction reversed on speedy trial grounds, for example, no eligibility under this statute, because speedy trial grounds you granted you win your appeal regardless of guilt or innocence, and therefore that's not grounds which tend to establish innocence.
Similarly, a motion to suppress.
Exactly, Your Honor. A jurisdictional
might or might not be, depending on how involuntary the statement was. If the statement is seriously involuntary, I don't know what that means, and that's the only evidence, that might be very different from there's a lot of evidence, and oh, by the way, the defendant's statement is suppressed because it was involuntary or wasn't, he wasn't given his Miranda warnings or something like that.
That's correct, Your Honor. In our brief, we list a whole series of grounds, and I'm sure the Court could come up with other ones, where defendants get new trials based on grounds that don't have to do with innocence. And I'd suggest that standard is much more workable. The standard that the Commonwealth proposes is that a Superior Court judge faced with one of these summary judgments basically redoes what the motion for new trial judge does and applies the question of, is this, and I think the language from the Commonwealth's brief is, does it meaningfully tend to establish innocence.
When you were discussing in your brief, you cite the recantation of several witnesses as grounds for allowance of the motion for new trial and as grounds for permitting this case to go forward. But didn't the judge, Judge Rouse, say that she was allowing the Commonwealth's motion for new trial, and that motion for new trial cited only the recantation of 2 witnesses? Or am I wrong about that?
She said that she reviewed the entire transcript,
Right.
that she reviewed everything.
But she
and
said,
that
I'm
based-
allowing the Commonwealth's motion. She didn't say, I'm allowing the defendant's motion.
But she did not say on what ground she was allowing the motion.
No, but
And-
that's why I read the Assistant District Attorney's statement, because he, in essence, is saying, as I read it, we didn't have a lot to go on. We didn't have a lot to go on. What we had is post hoc identification. That has now been called into question. I mean, I took it as an extremely forthright Assistant District Attorney, keeping in mind that the statute hadn't been passed. But this is not a case where you have, I don't know what happens if you have 2 or 3 witnesses who identify at the time, and one of whom it is later determined was being given certain inducements, you know, stayed in the motel or whatever it was, and that was not disclosed. But you've still got 2 eyewitness identifications. I don't know what you do with that. You're saying you would allow this anyway,
I'm saying
to go to trial,
I'm saying-
not necessarily to receive an award, but to go to trial.
And that's a key point, that what we're talking about here is whether the defendant gets to go to trial. So in terms of gatekeeping, there's another very substantial gatekeeper, which is once you get past this hurdle, you need to show by clear and convincing evidence you in fact did not commit the crime. But on this case,
That's not a gatekeeper, that's the merits of the case.
well, but I mean, in terms of the Commonwealth worried about the floodgates being open and people recovering all kinds of money against the Commonwealth,
Correct.
there's a heavy burden the defendant
It
still
seems
has.
to me that
No, the burden that the Commonwealth is concerned about, and certainly the statute is concerned about, is slightly different than that. It's essentially creating a whole new format to relitigate guilt or innocence, and clearly the statute was intended to narrow that to a very small band. I mean, the burden on the Commonwealth, it could be enormous, depending on what this small band, what this band is. If you're basically saying if it was material, in other words, it might have affected the outcome of the trial, that's sufficient to get past the first prong, right?
If it rises to the level where you get a new trial, which is more than material. To
well-
be entitled to a new trial, you need to show
No, material, likely to have affected
Yes.
the outcome of the trial.
that it tended to establish innocence.
No, that it likely affected the outcome of the trial.
And I'd suggest if you look at the phrase tend to establish, this court routinely uses the phrase. Relevant evidence is evidence which tends to establish a particular point of view.
Yeah, but
Evidence of
that's
motive.
different. That's different from saying it's one thing to say the Commonwealth failed to meet its burden of proof. It's another thing to say that the defendant hasn't proved that he didn't do it.
But the prove he didn't do it part is at trial. That's the burden in Section C6. Defendant needs to prove clear and convincing evidence he did not commit it. This-
Oh, I'm sorry. Please finish.
Yeah, sure.
Well, I wondered, how did you interpret what Judge Rouse said when she said there's only one conclusion that can be reached on the totality of this record, and that is that justice was not done and that this defendant was denied some of his constitutional rights to which he was entitled. One of those very important rights was the right to a fair trial. So she's talking about rights in the plural, one of which was a right to a fair trial. But is she also saying that it was the Commonwealth that denied him those rights? What was she saying there?
On the page before, Your Honor, she says the 2 issues that have been raised were failure to produce exculpatory evidence and newly discovered evidence. So I read when she says rights were denied that she's referring to those 2 rights. And those were the focus of all of the proceedings. And I'd suggest to the Court that when you look at the statutory language of tend to establish innocence, if you look at anywhere that phrase is used, it's used to mean suggest or move in the direction.
But when the governor sent back his amendment, and it said something, the original language said something about sustain,
Consistent with.
consistent with innocence, and he says tend to establish, which is obviously meant to be tighter, correct?
I think that's correct. I think the consistent with language would have said that in, for example, the speedy trial example I used, a new trial could be consistent with innocence. That is,
Anything can be consistent.
exactly, and I
but-
think that's why the change was made, because that consistent with language would have
No,
included
I'm suggesting that
anything.
maybe that's not what consistent means in that circumstance. I mean, it's one thing to, I mean, it just seems to me that you would, using the standard you're suggesting, and the appeals court obviously would probably agree with you, seems to me, though, is saying anytime you get a new trial on something other than Rule 36 or a motion to suppress, you're going to get money.
No, because you also need to have the charges dismissed against you, or null prost, or be found not guilty. So that's the first
Okay.
limit on it. You then need to convince a jury by clear and convincing evidence
But you have
that
to
you in
go
fact
through,
didn't
but you
do
would
it.
have the Commonwealth go through that whole trial.
I believe that's what the statute says.
And I assume that in those circumstances, I assume if the Commonwealth can then decide, now that it has the statute, which is why, again, I think that it's a little not unfortunate, but we have a proceeding that before the statute, that it can decide whether to null plus or to go through the expense of having a trial. If the Commonwealth thinks that, in fact, the person is guilty, they can decide to go through a trial.
I think that's correct.
Well, I mean, except if witnesses have died, I mean, that's of course part of the problem here, practical problem. Can't be retried because witnesses have died.
There has to be, for this kind of statute, there has to be a compromise made. Somewhere, clearly the legislature has decided not everybody who gets a new trial is entitled to compensation. So the line has to be drawn. I agree with you, Justice Gordy, that you could come up with situations where the reason there was not a new trial is because the witnesses had passed away. But it is a check. It is a three-level step. You need to first show you got relief on grounds which tend to establish innocence. You have to secondly show that the case was dismissed in your favor. And then you need to thirdly show by clear and convincing evidence that you did not in fact commit the crime. And I'd suggest if you look at the plain language of this statute, that's what it says, and I'd ask the court to enforce the language in that way.
Thank you,
Thank you.
Mr. Riley.